to Will Carly and Johnny podcast, brought to you by Subway sandwiches. Eat flesh. So
day after Halloween. Okay, so what we're gonna do then? We're gonna read. We're going through a hypothetical for contracts, and then after that, we're just gonna work through it together just to see how it all sounds, how we're all feeling about the final coming up on Friday. So we're just gonna read this elementary style. Is that what you had in mind?
Yes, sir.
Cool. Who wants to lead us out?
I'll go.
Cool.
Okay, facts. John Ashcroft, the early years. The first individual to be appointed Attorney General of the United States by President George W. Bush was former Missouri Governor and Senator John Ashcroft. Ashcroft soon developed a reputation as one of the grumpiest and most humorless men ever to hold office. Until recently, no one knew the source of Ashcroft's generally foul disposition and demeanor. You are about to learn about it.
It seems that earlier during Bill Clinton's final term as president, Ashcroft had become so disgusted with politics that he retired temporarily to a house on his ancestral farm in Fort Stinkenbog, Missouri, intending to make his living off the land. The farm, which Ashcroft had inherited from his father years before, was a 100-acre tract suitable primarily for grazing cattle. It was known locally as Ashcroft Acres. Immediately to the west of Ashcroft Acres, separated from it only by a, I don't know that word,
Dilapidated.
barbed wire fence, was the 100-acre farm of another celebrated son of Missouri, Bird, and a Bush, reputed to the next heir of the Anheuser-Busch beer fortune. Bush was a lazy and largely useless individual whose only strategy in life seemed to be to gamble away his trust funds and wait for his wealthy relatives to die so that he could inherit his fortune and move to the big city. Meanwhile, he was chronically short of cash and stuck on his farm, which was known locally as Bud Light Acres.
Bud Light, okay. The land along both sides of the border between Ashcroft Acres and Bud Light Acres. So the land in between both of those formed a large, malodorous, unpleasant swamp. So there's a little swamp. The swamp rendered about 10% of Ashcroft Acres and fully 50% of Bud Light Acres. So half of Bud Light's is swamp. Absolutely useless for any purpose to anyone but the local frogs. This had never been of concern to Ashcroft while he was involved in Missouri state trade. However, when Ashcroft took his break from politics, Bush saw an opportunity to improve his land without having to do anything resembling physical labor himself and without having to spend any money.
One fine spring morning, Bush invited Ashcroft to join him for a cup of coffee at the local diner, the Reflux House of Grits. During the course of an extended conversation, Bush presented the following proposal. Bush, tell you what I have in mind, Johnny boy. We need that swamp drained. You need it, and I need it even more. Ashcroft, I agree, and don't call me Johnny boy. I'm a lawyer. I'm a serious guy.
Bush said, lighten up, Johnny boy. I switched to decaf. Anyway, here's my offer. You dig a drainage ditch along your side of the border between my farms, stretching all the way to Stagnant Creek in the south. I figure that that will be enough to drain both farms and make all the land useful. In return for that, plus $50,000, I will convey 1/4 of Bud Light Acres to you. You can have the 25 acres that abuts the current border between two farms. We can go out and step it off now if you like. You can pay me $5,000 as a down payment tomorrow, 10 days after you complete the ditch, and I'll give you a deed to the 25 acres currently included in Bud Light Acres, and you can pay me the remaining $45,000.
Okay. No, you finish it out.
Okay. Ashcroft said, well, I'm surprised. 25 acres for $50,000 in a ditch? Sounds like a pretty fair deal for everyone. In fact, you have a deal. Let's shake hands on it and go mark off that portion of Bud Light Acres I'm buying.
Okay. The two men shook hands on their agreement and proceeded directly to Bud Light Acres. Once again, they marked the 25 acres Bush intended to convey with a series of stakes, posts, and marks carved on trees. The next day, Ashcroft paid Bush the $5,000 down payment upon which the two had agreed in their conversation. Ashcroft then began to investigate ways to dig the drainage ditch required by his verbal agreement with Bush. Okay. He checked with a series of local excavation contractors, any one of whom was willing to do the job for $50,000. Okay, this is layered. However, Ashcroft happened to own a bulldozer and a backhoe as part of the equipment on Ashcroft Acres. He also thought a stint of hard labor out of doors would help him forget the scandals surrounding the Clinton administration. Okay. So he spent the next 30 days manning the bulldozer and backhoe, cheerfully digging a ditch across the western edge of his own land to Stagnant Creek. Okay, so there's some performance. In the process, he removed the barbed wire fence that marked the current border between Ashcroft Acres and Bud Light Acres because he contributed his own labor. His only out-of-pocket costs consist of $5,000 for gasoline and vehicle maintenance. When Ashcroft completed the ditch, it did exactly what Bush predicted it would. It drained all the swampy land of both farms, effectively reclaiming what had been useless acreage.
Upon completion of the ditch, Ashcroft notified Bush by email that he would be prepared to pay the remaining $45,000 in 10 days as they had verbally agreed, and that he expected a deed to the 25-acre designated portion of Bud Light Acres at that time. He received a return voicemail message from Bush saying only, "See you in 10 days, Johnny boy."
10 days later, Ashcroft arrived at Bush's door with a cashier's check for $45,000 payable to Bush. Bush was nowhere to be found. The only person on the premises was Bush's caretaker, a large, unpleasant fellow named Bubba, who had an annoying habit of carrying a shotgun everywhere he went. Bubba refused to accept the check. Instead, he handed Ashcroft the following handwritten note from Bush. You want me to read that?
Yeah.
Cool. Dear Johnny boy, I've been watching you dig like some hired hand. You grunted and sweated and drained both the land. I don't know why I'm reading it like a poem.
I think it is a poem.
Oh, okay. But I've changed my mind, though it seems such a pity. I'll give you no deed. I'm off to the city. Please put back the fence. You shouldn't have moved it. And don't talk a contract. You really can't prove it. Sincerely yours, Bird.
Okay.
Yeah.
You son of a gun. Ashcroft's initial reaction was the appearance on his face. For the first time of the famous grimace with which we are all now so familiar, to this day you can see it every time he appears on television. His second reaction was to consult his lawyer. You are that lawyer. Advise him.
Alright, well I think ultimately, if we're summing up the facts, he wanted this land, he paid for parts of it, well they shook on it, paid for parts of it, he went and performed part of it, and then later they went and, well, Bird backed out on the deal.
I think it'd be helpful to break down the first part of these contracts, because I think there's multiple contracts in here, yeah?
I think so.
Would y'all say it's one big one, or multiple small ones?
I kind of want to say it's one big one. With, smaller terms inside of it.
Yeah, I think it's one.
Okay.
Offer.
Would y'all want to do, what are relevant facts right now, or would you want to, run through analysis?
Let's just do a quick analysis, and then we can see where that leads us.
Okay.
Any thoughts?
Okay, let's do it then, yeah?
Okay. I mean, I have some ideas, but if someone else wants to go first, I can share my ideas in a minute.
I guess we'll, go through the statute of frauds analysis.
No, I mean, because that's the really big thing staring us in the face. It's going to be statute of frauds.
Okay. So...
It's for land.
Yeah.
It's for land. So we know that...
It's got to be written unless there's an exception. Unless he's performed partially. And in this, I think in these cases, it's if you have possession of the land and if you've improved it.
Mm-hmm.
So, enforceable.
And I don't think this is going to fall underneath the UCC because, yeah, it's land. It's something that's not movable, so it's not a good,
Yeah.
which means we are going to go to the restatement, and the restatement, like you were saying, has the land factors in it as well.
Yes.
Okay.
I think it is worth noting too that is predominantly land, right? Like, because there are goods in here, but they're not like
the
main,
tractors and
yeah,
stuff.
but they're not like the main show.
Definitely. Okay, statute of fraud steps. We covered UCC. It's not under the UCC because there's no goods, like you said.
Yeah.
So we're going to move to the restatement.
And is the contract one of the types to which the statute of fraud
And this is what you had said.
Yep.
It's going to be yes, because it's a sale of interest of land.
So now is the question of whether there's sufficient writing.
Yes.
And
that is the
we
question.
would say no.
Nope.
The fact pattern that reveals that is, I mean, the only real writing it would seem like is this note, but that has nothing to do with the subject. Well, it has to do something with the subject matter, but not necessarily.
And that
The
note was a
contract.
revocation of the quote-unquote offer. Everything else was done verbally. And so, yeah, the statute of frauds was not met. It's going to come down to, do we have an exception of the statute of frauds through the restatement?
Yeah. So what would you say, Carly?
under the restatement? Performance has to be completed, right?
It depends on the jurisdiction. So,
Okay.
part performance, full performance. I think the restatements do say full performance. The one case that we had looked at in class did say partial performance was fine, but it's gonna be what's the restatement section in.
So what would you invoke, Carly? What section would you think about invoking?
Okay, I think it's restatement 45. Option contract created by part performance or tender, where an offering. Well, is it an option? Yes.
I think it's
not an
more
option,
promissory
it's an offer.
estoppel.
Yeah. So 90 then.
I think 90 is the right one.
Yes. Why 90?
Well, because it's a promissory estoppel, I think it's going to be a matter of whether or not the jurisdiction is going to say full performance or partial performance, because he relied on the promise. Well, so we're missing a contract here, so we're seeing if he can actually have this enforced. So he relied on the promise, meaning that yes, he went ahead, paid for part of the land, did all the work for the land, and drained it from the swamp-like condition that it was in, and then went ahead and tried to pay for the rest of it. So he relied on the promise. It was reasonable that so there was a promise made. He relied on it, and then he suffered it to his detriment because he spent all that time, all that money on it, only for Bush to say, no deal.
Why wouldn't it be 129?
Ooh, I think it's 129. Wait. I need a poll.
Or 139?
Okay, on 129, that's interest in land. Contract for transfer of an interest in land may be specifically enforced, even if not compliant with statute of frauds. If P in reasonable reliance and with the assent of the defendant has so changed his position that injustice can be avoided only by specific performance.
So do you think it's a 129?
I think you would go to 129 first, and then promissory estoppel.
Yeah, so 129 is what we did for step one, saying that this is interest of land, and so we're going to go to promissory estoppel, which you said was 139, right?
It's just 90, right?
Well, so I think promissory estoppel. Oh, wait. So if it's relating to the statute of frauds, we move to 139, which just says that promissory estoppel is going to overpower the statute of frauds, which is promissory estoppel is defined in section 90. So we start at 129, move to 139, finish at 90.
So we're definitely invoking 129. Like everybody in agreement there.
Yeah, because that's just saying statute of frauds needs to apply if it's a sale of interest of land.
Well, it also says it doesn't stop there.
Yeah, but as far as
then it starts saying everything that's in section 90.
Oh, gotcha.
It says in reasonable reliance on the conduct and on the continuing assent of the party against whom enforcement is sought. So I don't think you would need 90 at all, would you?
I don't think we need to
Probably
invoke
not
90. I think I do want to add to, like, I think for extra, like, points, so to speak, I think we would invoke 139, because it does seem like...
I don't even know what 139 is.
It does seem like...
139 is just saying promissory estoppel overpowers statute of frauds. So if we can find that there's promissory estoppel, then we're good here.
Okay, I see.
I think it's also very clear that Bush here was trying to use trying to use the statute of frauds to get out of a contract.
And did so fraudulently, which is ironic.
And so subsection 1, I think, would definitely apply. I think, so the facts that I think would support that, like if running through the analysis for sure, is like everything here indicates like a contract.
Mm-hmm. And reliance on that contract.
Yeah, and especially since they shook hands. Like that is a very classic way of like societies to look at each other and shake hands, to be like, this is a very mutual assenting like behavior right now.
So are you arguing that there was a contract, and if that's the case, then we don't use promissory estoppel? Because promissory estoppel is what we use if it looks like a contract, but it's not a contract.
I think so. I think you... Oh, actually, that's a good point, huh?
I feel like what you're saying is this is why his reliance was justified, was because you could assume that shaking someone's hand means...
Yeah. So, hold on. So, addressing Carly's point, I think my reason there was that, like, because one of the elements is that the person could reasonably foresee action or forbearance from the other person. But then alluding to getting to Will's point is that promissory estoppel is invoked when where there's like a reliance on a promise, like it isn't a clear contract, because if there is a contract, then you just run the contract. And so it doesn't become enforceable from estoppel. Is that what you're saying, right?
Pretty much.
So actually, I didn't even think about that. But I think my hesitancy is like, because we're running the statute of frauds analysis.
Yeah.
Right?
That
like,
makes it difficult.
Like...
This is the issue that we ran into in
because
class.
It can't be a contract unless it's in writing because of the statute of frauds. But because he's already done all this stuff in reliance.
Yeah.
But that doesn't mean there's a contract, right?
What is required for a contract is promises. Well, it is a promise.
Like there's an offer.
And consideration, really.
There's a clear offer. There's a clear consideration, and I think there's clear acceptance.
So you are arguing that this is a contract then?
But I also, like, I don't know if, like, by definition, statute of frauds, it just trumps. Like, you have to run that analysis first, and if it doesn't work, then you fall back on everything else. Do you know what I mean? Like, is that the analysis that we're going through?
I don't think so. I think it's statute of frauds.
Statute of frauds.
Just statute of frauds.
Okay. That's
because
how
otherwise it would just be, like, you would say, well, it's not a contract because the statute of frauds needs it to be in writing. Mm-hmm. But if it's not in writing and there's offer, acceptance, consideration, it is a contract. But that doesn't, because you're just going to go back and forth the whole time. Do you know what I mean?
Yeah.
Okay, so really just summing up everything so far. We read the fact pattern, determined that there was some reasonable reliance. We're going to have to run the statute of frauds things, which we did when we first started going through it. Statute of frauds is required because its interest in land was not met because it was not in writing, but there is a sufficient exception because of promissory estoppel. Is that our final analysis for this question? Can we see answers on
there are
Aspen?
Answers, yeah. So the answers would be under essay examination answers?
What's it say?
Okay.
It does go through statute of frauds.
So it goes. So the first point is offer and acceptance. The conversation between Bush and Ashcroft meets the basic requirements of offer and acceptance for the formation of bilateral contract. Characterizes proposal as an offer. You have a deal coupled with a handshake. It's unequivocal acceptance. And then it runs through the statute of frauds. Do you want to read that, Carly? Okay.
I got it. So under the statute of frauds, a contract to transfer an interest of land under Section 129 of the restatements, must be in writing signed by a party against whom enforcement is sought, and the writing must adequately describe the land. This agreement required is a transfer of portion of Bud Light Acres, and it was never memorialized by writing. It is therefore unarguably unenforceable. However, there are recognized exceptions to the statute of frauds.
Okay, 6. So we've been like 95% right there.
Yeah.
Okay,
Perfect. Part performance exception to statute of frauds. The land clause of the statute of frauds is subject to a part performance exception. If the vendee, under a verbal agreement to transfer an interest in land, engages in sufficient partial performance of the agreement, the bar of the statute of frauds may be removed. The basis for this exception is that the conduct in question provides an evidentiary substitute for the writing required by the statute, and that in absence of enforcement, the statute of frauds would itself operate as an instrument of fraud. The difficult question with the part performance exception is determining what type of partial performance is sufficient. Payment of the purchase price or a portion of it is alone not sufficient. There must be additional conduct that is referable to the agreement in dispute. On the other hand, payment plus taking possession of and making permanent improvements to the land is normally enough. In this case, Ashcroft has made partial payment, but he has not yet taken possession of the agreed portion of Bud Light Acres. He has removed the fence between Ashcroft Acres and Bud Light Acres, and he has dug a ditch on his own side of the original border. The former seems consistent only with the alleged agreement, but the latter is consistent either with the alleged agreement or with a simple desire to improve Ashcroft's own land. It is thus not clear whether a court would find Ashcroft's conduct sufficient to qualify for the partial performance.
So ultimately, it's going to come down to this is going to be a jury question.
This is not necessarily referring to restatements at all. If we were trying to nail down that one for partial performance, what would you say that is?
That would be...
I think 129 was right.
Yeah.
Action and reliance. That's specific to land, though. Did you want...
Is there one that says partial performance? Or would we just end up invoking, like, the previous statements, you know what I mean?
It's restatement 129. But...
For sure? With partial performance? Because it doesn't have the language of partial performance.
I'm not sure. I don't really...
Well, my notes for restatement 129 just pretty much says is that it can be enforced by specific performance if there is reasonable reliance, part performance, and it can only be enforced by specific performance. That's what I have for my notes on 129.
Yeah. Well, I mean, because I only say that because later on it talks about number 5, promissory estoppel exception to the statute of frauds, and so I don't know if that's going to be separate.
It definitely is.
Yeah.
I was under the assumption performance had to be complete. I didn't think partial performance worked under the restatement. I thought that was only the UCC.
I think it needs...
It makes more sense that it would be allowed under the restatement. Definitely.
Yeah.
I think that's where our question and gaps are, and that's probably just what we'll have to focus on when it comes to actually...
Didn't you just ask Vestal about this?
I think
it 130?
This one might be invoking 50, wouldn't it?
50?
I mean, because we can also run the offer acceptance right here because it confirmed that part of the contract was there. 50 subsection 2.
What's that say?
Acceptance by performance requires that at least part of what the offer requested be performed and tendered includes acceptance.
Oh, that's for a unilateral contract, isn't it?
No, this is bilateral.
Well, acceptance by performance is a unilateral, isn't it?
It can be, but it's
that's
both,
true.
Right?
You can ask for the promise or the performance.
Yeah. We'll just keep reading. Specific performance remedy. Okay, so this one feels like specific performance being like granting of the land. Like that feels like 129 because 129 was oddly specific, right? Of like
129 is specific to land.
It's very specific, and it's specific to the remedy as well of specific performance of granting the land.
Mm-hmm.
Right.
And so, 4, assuming the partial performance exception of the statute of frauds is applicable to this situation, Ashcroft has the clearest and best remedy. The part performance exception would enable Ashcroft to obtain a decree of specific performance. In order to qualify for specific performance, a litigant must establish that, absent equitable relief, his remedy at law will be inadequate. So that's consistent with 129 as well, of like you exhaust every other remedy. One form of inadequacy of remedy at law is established if the subject matter of the contract is unique. Okay. Each parcel of land is presumed to be unique. Thus, in land sale contracts, specific performance at the request of the vendee is granted almost as a matter of course. That makes sense, right? Because each land is unique in its own right?
Yes.
There is only one possible obstacle to specific performance. The court must be able to identify the land in question in order to formulate a specific enforceable decree. While there is no formal legal description of the tract in question in any of the parties' communications, Ashcroft can argue that the measuring and marking of the tract that Bush and Ashcroft performed together is sufficient to enable an equity court to fashion a proper decree. Finally, specific performance will not be ordered if the returnee performance by the party seeking it is insecure. Specific will not be ordered if the return promise performance is seeking is insecure. Therefore, Ashcroft will succeed in obtaining specific performance only if he remains willing and able to pay the remaining $45,000 of the purchase price.
Makes sense.
Oh, okay. So this one's saying that like partial performance is not enough here. Like you need to actually do this thing, right?
What it's saying is that the court will make sure that specific performance occurs as long as you make full performance.
Yeah. Okay.
It's the only fair way to get the land.
Yeah.
That
Otherwise, you would just get damages, right? Which is out of pocket.
Yeah, totally makes sense. Okay, so looking at everything so far, we're looking at it is a contract, statute of frauds. We're going to say part performance is an exception to the statute of frauds. As far as the remedy goes, it could be specific performance, or we could also take it the promissory estoppel route.
Which, Carly, take it away.
Oh,
that's a lot.
Promissory estoppel exception to the statute of frauds. If the part performance exception is not applicable, Ashcroft must find a different way of removing the bar of the statute of frauds. He might try to enforce the agreement on the basis of promissory estoppel, which in some jurisdictions may substitute for the writing required by the statute of frauds. Here again, the theory is that the conduct upon which the estoppel is based is a satisfactory evidentiary substitute for the writing, and that, unless the defendant is estopped to plead it, the statute of frauds will operate as an instrument of fraud. Liability on the basis of promissory estoppel requires that the defendant make a promise on which the plaintiff's reliance is reasonably foreseeable, that the plaintiff reasonably rely on the promise, and that injustice be avoidable only through enforcement of the promise. In this case, Bush's offer invited reliance in the form of payment of a portion of the purchase price and excavation of the ditch, and Ashcroft actually relied by doing both. His conduct in removing the fence was not invited, but was arguably foreseeable in view of the contemplated location of the ditch and the subsequent conveyance of the contiguous land. It is therefore arguable that Bush is estopped to plead the statute of frauds. There are two possible problems with the foregoing analysis. First, the extent to which promissory estoppel is available to remove the bar of the statute of frauds is uncertain as a matter of case law. A general promissory estoppel exception to the statute of frauds has been recommended by the drafters of the Restatement Second of Contracts, but not all jurisdictions have adopted the restatement view. Second, the appropriate remedy in the case of a promise enforceable under an estoppel theory is still controversial. On the one hand, it may be argued that a promise enforceable under an estoppel theory that a promise enforceable on the basis of estoppel is, in all other respects, an ordinary contract for the breach of which ordinary contract remedies should be available. If that is the case, specific performance should be available for the reasons outlined above.
Nice.
On the other hand, it is arguable that if the basis for enforcement is reliance, the available remedy should be limited by the underlying enforcement rationale. In that event, the only reliance damages would be available. Ashcroft would be able to recover his down payment, the $5,000 he spent on gasoline, plus whatever value could be assigned to his labor.
Okay, perfect. So that really answers the question that we had before, where it's saying if this is a contract, we can't use promissory estoppel, and we need to go with the a specific performance, well, the part performance exception route. Yeah. And if it is not a contract, then we can use the promissory estoppel route.
Exactly.
Wait. Without a contract?
We use promissory estoppel.
Yeah, and then with a contract?
We use part or specific performance.
Gotcha.
Yeah. There was the little tidbit, too, on jurisdiction. For Vestal, we're just going to assume the restatement.
Yes.
But I guess, for practical reasons.
I'm not even worried about practical reasons. Until I graduate law school, I don't understand.
Okay, last one, implied. Okay, restitution. Implied contract, quasi-contract. Ashcroft's final option is to pursue recovery under a theory of contract implied in law. It is well settled that even if a contract is unenforceable under the statute of frauds, one who confers a benefit on the opposite party in attempt to perform it may recover in quasi-contract for the purpose of preventing unjust enrichment. Thus, Ashcroft could clearly recover the $5,000 portion of the contract price he actually paid. Moreover, one who performs services at the request of another with a known expectation of compensation is entitled to recover the reasonable value of the services performed. Here it is demonstrable from the offers of other excavation contractors that Ashcroft's service in digging the ditch had a market value of $50,000, and he is presumably entitled to the amount in restitution in addition to the restoration of his down payment. Bush might argue that because the ditch was actually located on Ashcroft's acres, not Bud Light acres, he had not appropriated the value of the benefit and therefore was not unjustly enriched by Ashcroft's excavation efforts. Interesting. There are two replies to this argument. First, that there is some case authority that where services are performed on request, they are presumed to be of value of the party requesting them equal to their market value, whether that party appropriates the results of the services or not. Second, as a matter of fact, the ditch does drain Bush's land, and there is no alternate way under the facts given to place a value on that benefit.
Big takeaway from all of this, Bush messed up. So...
Yeah, I think we did pretty okay. Yeah.
Yeah, that part performance thing is annoying. I do want to know what section it is.
That one's...
I think what it is restatements say full performance, and then jurisdictions are going to allow part performance. Possibly.
So, okay. So then, he paying the $5,000 and digging the ditch for our purposes would not be enough to make it an enforceable contract.
No.
Okay.
But if the jurisdiction says that it is, and then he would just have to pay the rest of the full amount to make it full performance.
That makes sense. See, that seems more fair to me. And more common sense to me.
It does make more common sense for sure.
I just have to forget about it.
Interesting. That, honestly, that makes me feel like not terrible.
Could be better, could be worse. But overall, I think we did all right.
Yeah, that would be like at least 20 points out of 33.
Yeah.
Right?
Yeah, at least 50 out of 100.
Yeah, I hope so. OMG, I can't even think about
I'll admit, though, I didn't even think about the restitution route.
Yeah,
I
have that.
The thing is like, I feel like Vestal wouldn't want us to go the restitution route.
No, he just wants the best way, or most convenient way.
Yeah. Keep it as close as possible to what makes sense logically.
Yeah.
Okay, so just to make sure that we cover our bases, where's this come from? This hypothetical that we read?
Oh, we still on?
Yeah.
Oh, it's on, I don't work for them, but it's on Aspen Learning. And target audience is probably folks that go to my school here.
What's the name of the book? Oh.
Author is Joel W.M. Friedman.
Contracts.
And the book cover has a gavel on it, so if you forget all that.
And it's blue.
Perfect. I think we're good. You guys good?
I'm good.
Solid.
I feel good.
Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.